However, we're 3 months into a moratorium, and I have an issue with the fact that we're 3 months into a moratorium, and this is the first time we've all sat down to figure this out. I think we need to keep things going forward. If we need to sit down on a monthly basis and throwing this out there to get through this and get things figured out, I think it's something that we need to do. There's, you know, the workable local ordinance, I mean, basically is what we did with Smear's company. Yes, it fell under the CREO, but it was a workable local ordinance. They agreed to things that were outside of the MPSC's Public Act 233 regulations. So basically, we combined the workable local ordinance with the CREO, and that's how we went about it. I think the workable local ordinance gives us a little bit more control of or negotiating power with the contractors for things like setbacks, for things like berming, for things like screening, fencing, that normally under the MPSC Public Act 233 we wouldn't have. I use an example. I've been talking, as well as the landowner has been talking with that particular development about, you know, the public wants to see agriculture on the land. Okay, great, let's control the foliage with sheep. The developer's willing to do that. That's something that under a CREO, we don't have the negotiation power to create that. Under a workable local ordinance, we can go to that developer and say, we'd really like to see agricultural remain. Can we control the foliage with sheep? The developer very well can agree to that. These guys are open to looking at it. As an example. Another example is you got a landowner that's willing to offset the 1,200 acres with another 1,200 acres and put it in the USDA conservation program to conserve the land. Whether he's doing that, I don't know, with the developer and they've worked out something, or if he's doing it on his own. But the fact is under a workable local ordinance, we have where we can work through that and we can negotiate things like that. Under a CREO, we can't. Under a CREO, we have to follow Public Act 233, and we can't go outside the boundaries of what the state has said. So if we want any kind of local control at all, the workable local ordinance is the way to go. I mean, basically you got two options, or you got no ordinance. If you got no ordinance, these guys have to go to the state. When they go to the state, we lose the county, as well as the townships lose funding. And we also lose any power whatsoever of negotiation with the contractors or with the developers to limit or, you know, offset the resources that are there that are being used. So,
Can I get some clarification on that as far as the county and townships? I had to go watch the class on that, and I believe you guys still, or the townships still get monies even though it goes to the state?
In which level?
For township and county level with the solar stuff, if they go to the state, you guys still get funds, correct?
Well, there's two things. If a developer goes to the PSC, there's intergator fund, open to the communities, so that can be the county or the township goes in. As far as if the development comes in, the state has an incentive program available if communities want to apply for that, get monies under the incentive program. So that's nothing to do with what kind of ordinance we necessarily have. That's whether development comes through and we choose to apply for it. In the case, if they go right to the PSC, we're not eligible to even apply for that. So
right.
If I understand, definitely with a CREO, I believe with a workable, we could.
I have a question. How many, do we know how many have gone through the state and been approved? Do we have that number?
I thought there were how many have gone through the state and been approved.
None.
Have been
Zero.
approved.
There's 10 and none have been approved. Who else has their hand up, Chuck?
I just wanted to get a little more information in regard to the contracting. In fact, when we issue an SUP, it is a contract, but it's a contract for land use. It's not a contract as you might see elsewhere. I was a contracting officer for the Corps of Engineers for 15 years. Our criteria was a contract would be awarded to the most responsible party. Now, responsive means they had to comply with all the regulations that we had in the contract. That's one thing. Responsible fell back on your questions as to whether the person, the contracting entity, has the financial capability of fulfilling the contract. As a contracting officer with the Corps of Engineers, I had to look at both. I actually turned down one multi-million-dollar contract with a contractor that had the lowest bid, but he wasn't able to comply with the financially with the terms of the contract. Matter of fact, the water intake for the city of Detroit that was up in Lake Huron. And I had to go to the contractor, who happened to be Greenfield Construction, which was the head of it was Angelo DePonio, who was the head of the mafia in Detroit. And I had to go in and explain why he wasn't going to get the contract. But ours is not that type of a situation. We can't look at that half. We're looking at the responsive from the standpoint of the land use. We can't look at any of these other things.
Chuck, can those things be looked at as part of a special use, or I'm sorry, a site plan approval? At that point,
The financial capability of the firm?
not even at a site plan?
No. We're strictly land use. And our regulation has to be built around criteria for the use of that land, not whether the guy is going to go bankrupt tomorrow or he's bankrupt already.
Okay, we have a question here from
I just wanted to comment on Ms. Webb's question about the commission. And to the best of my knowledge, they have not approved a single project. My understanding is there are 8 currently in front of them. The most recent was the Silver Maple project out of Muskegon County. But they told Ottawa County, they told Ottawa County in that hearing, which would have been Wednesday or Thursday of last week, I've been following these on a regular basis, trying to stay in front of the game, that it would take every bit of the 1 year that the law allows in order to issue the permit, that they would utilize every day of that. Interestingly enough, in that exact hearing, they opened the door very wide when it comes to intervention. Now, in the situation here in Cheboygan County, as we go in to intervene, our understanding would be ourselves and Grant Township that are interveners. But based upon what happened in Ottawa County, that door was opened so wide, there are in fact over 20 individual citizen interveners. Now, how much of an effect they're going to have in the process is questionable, because in order to succeed with the MPS, you need to be dealing with facts and figures. They're looking at science and looking for science to justify things. So it'll be interesting to see what happens as this goes along. They have not approved a single project yet, and they're probably, based on their timeline, they're probably 9 months away from approving the first project. Yes?
Do they have to approve that if the year is up? You talked about 1 year.
By statute, they have a year to do it. My guess would be, Mr. Kavanaugh, that if they don't, they can't get there from here, and they may not be able, they've created quite a Frankenstein here and with their process. And I would assume that if they got to a year and they were not able to meet that deadline, they would probably ask for an extension. But, you know, this is all subject to, who we have as a Attorney General on January 20th of next year here in the state of Michigan, because it's flawed legislation and very apt to be thrown out with bathwater and baby at the same time, very quickly next year at some point.
So it's
Perhaps
not
even
automatic.
before they can approve the first permit.
Not automatically approved after 1 year.
No, no.
But
Not
sometimes
automatic.
that happens.
And as they've opened the door so wide to the intervention process, you wonder just how many hours the hearing will take. A lot of people, well, over 20 in Ottawa County, that plan on coming forward. But unfortunately, again, they won't be coming with facts and statistics, they'll be coming with a personal appeal as to why they don't, and that does not bear a lot of weight.
And they put all their comments right on their website too.
Yeah.
The
Word for
reason
word.
the reason I asked was because I was at a Leaping Lakes event down in Walden a week and a half ago, and they, Consumers Power was there, and they talked about the fact that they were just about this close to being approved for, and I don't remember where the guy said it was, but,
I believe the Consumers Project proposed in Cheboygan County, is there not, Michael?
Yes,
Yes, there is. And I don't even believe that one's been filed with the state yet.
it happened, the Consumers Energy has said that they were waiting to see what the outcome was with the ones that they've already had filed. But the miscommunication, according to the MPSC's website, they've approved 1,269 megawatts of utility scale solar contracts for Consumers Energy,
okay, that's
To
what I
date.
think he was talking about.
Approved.
which means that the one in Cheboygan will probably be filed shortly. And they told the landowners that they were waiting on, so.
Just continue on the workable ordinance side. So as you can see, the benefits are also greater local customization of the ordinance. With that being said, it's a balance to add information or provisions under our language with something that, to my knowledge, hasn't been challenged yet in the court setting. So if we're going to workable, we can outline what the ordinance is, work through that, work with what our conditions, approval will be, and whether they're special use or whatever avenue we go that way. But we have to know at the end of the day, if the developer goes through the process and doesn't get the outcome they're looking for, they can still supersede that and go straight to the state. So it gives us ability to negotiate to a certain degree. I would say the negotiation would be based on objective standards, measurable type standards. When you go outside of land use regulation also, although this has not been tested and there's not a lot of ordinances out there, based on being around a while, 35 years, I'm not sure provisions such as whether they have types of livestock would be able to work under general land use law. Different things on landscaping and setbacks, probably discussions on districts and things like that we could do, but in the operational sides, I'm not sure, because based on primary basis of land use theory there, and get into that level of operation, that's not something that we can do with other types of special use permits. So I'm not saying 100%, but that type of thing will have to be researched. As far as financial, as we stated before, we have to, by due process, move applicants through, regardless of what their background is, or financial capabilities, or actually for anything else, as long as they haven't committed a crime and end up in court system or something like that. But with that being said, as far as having the provisions for removal, bonds can be incorporated into certain types of projects. We have those in other types of special use. So that's the only area. If you have a bond standard, you simply just have to be able to get a bond. You're not reviewing anything of their financial history or anything else. If they can produce a bond, then that would move forward.
salient to what Mr. Lawson said, in my estimation, and you would recall, those planning commissioners that were serving or that had served last year during the Northern Waters project, in discussing the project within sort of the context of PA 233, the significant difference is that our Section 1730 has provisions or requirements of performance standards for screening, whereas PA 233 does not. And that relates to this discussion consideration number 2, to what extent should local regulations differ. As Chuck Freeze alluded to a few moments ago, in my humble estimation, we have a strong basis for a workable ordinance already per Section 1730. Now, does it need refining, massaging? Yes. And screening requirements are integrated into that Section 1730, but just wanted to point that out just as a reminder. That seemed to be the overarching difference between our ordinance and what the applicant was willing to do and what PA 233 requires.
Decommissioning in the,
Right.
it was in our original ordinance, and they accepted that was part of the SUP that was granted the second time around.
I just have one other question, Senator. As these things progress and they go into production, does the county have someone or some way to monitor this, to see that these terms and conditions are being met?
Well, that's an excellent question.
No, well, a lot of people
Yes.
want renewable resource people, they're actually talking about that as a position in some other units of government to just do that.
Well, we don't currently have that.
Well, for a project like utility scale solar project, that would require the oversight of specific experts and reliance to some degree on the respective agencies that also have a hand in the oversight and enforcement of a project. DNR, Eagle, as far as performance bonds, those would be reviewed by legal counsel. Staff would review and monitor for the some of the performance standards, namely the setbacks that were approved as part of the site plan. The extent of the array field, for example, sort of the physical aspects. We do have the authority in the ordinance to secure experts in whatever field that planning commission feels is necessary to review aspects of a project that in-house staff doesn't have the expertise or the capacity to review. So a project of this scope and scale, or that scope and scale, requires more than planning and zoning staff to make sure things are moving forward as approved.
Yeah, you got Steve first, you wanted to say something?
No.
Okay, Galen.
I just have a question. Going with the workable, can we restrict which districts this would be approved for?
Yes.
In other words, can we restrict, we're saying, we don't want this in lakes and streams, and we don't want this in, I'm sort of into agriculture or forestry. Can we restrict that?
Yes.
Because this third project is in a lakes and stream. For the life of me, I have no idea how that ever got approved. I mean, when we look at our master plan and working going forward here for the next 10 years, I think our constituents want to secure the property that we have. In other words, make sure that in 30 years, because if you go out to the Arizona desert, you can see a lot of these things rusting away, and they were bonded, but for whatever reason, for legal reasons, the bonding never appeared. In other words, the insurance companies or whatever, they said, well, you didn't meet this requirement type of thing. And now they set. And so my concern is my grandchildren have Cheboygan County still here, and that we as the government governing and appointing members protect those lakes and streams in these certain areas that are, they're the hallmark of what we are up here. I was born and raised here. My family has lineage all the way back to the beginning. And I want to make sure that my grandkids have that same protection for these areas. And I mean, like I said, if we can do a workable, and I agree, Chuck, I don't think we should turn it over to the state, but I think we should be as restrictive as possible to ensure that we protect what God has given us here. This is God's country, and I think we need to be as restrictive as possible within the legal confines. And I know this is supposed to be a go forward because we're in a moratorium. And my input would be that we provide guidance to our planning commission saying, look at the master plan, protect these certain areas in this ordinance, in this workable ordinance. Because myself, I have no clue why this solar farm is in a Lakes and Stream area.
I just like to
You got
follow up.
somebody perhaps,
Good.
excuse me, Bill, can we come to an understanding as to how this did get placed in the, because that's all my heartache is the same as yours, Commissioner Claremont. You know, how did we wind up placing this, like, the worst place we could possibly? How did that happen? How does that happen? Thank you, Chuck. Go ahead.
Thank you. Go ahead. I don't know who's passing out.
No, the chairman would be doing that.
I raise my hand. Anyway, the choice of where any use is authorized is placed in the regulation at the point in time it's written. It can be changed by amendment to the regulation. If you look at Lake and Stream, the solar farm is an authorized use with a special use permit in Lake and Stream. It is authorized in Forest Ag. These choices were made at a point in time where that regulation was written. It was subject to the public hearings we had, and everybody was considered, and the Board of Commissioners approved those uses in those districts. That's how it came about. Not to say that it can't be changed, but that's how it came about.
Good, that's
If I-
good. Thank you.
So Chair, if I may expound on that, I mean, you had asked sort of the history or background, some background information as to how PLS was injected into the list of, well, from my understanding, from my recollection, well, firstly, lake and protection zoning is quite prevalent. It's the second most prevalent zoning. Now, when I look at a zoning map of the county, visually speaking, it looks like it's very close in terms of area percentage to our ag forest zoning district, which is the most prevalent. But it's spatially narrow, Lincoln Street. But going back a little bit, the line of thought back then was, Chuck, correct me if I'm wrong, we tap into historical memory quite often. Given the